So unfortunately, there's a lack of consistency at and with immigration with USCIS when they go to adjudicate cases. So again, when I go back to the sort of friends and colleagues example or scenario, you may have a friend or a colleague who filed a similar application. Theirs may have been adjudicated more quickly than yours. What does that mean? Well, it means that immigration, USCIS, are inconsistent. And I wish that they were not, but they are. So it's frustrating, yes, but it's not, unheard of for similar cases to be adjudicated under different timelines. One thing, however, to their benefit, we did see last fiscal year, so approximately about a year ago, and so let's see how it works in the last couple of months of this year, is that they actually raced to issue many green cards based upon employment-based applications last year. So we did actually see them get through a lot of the backlog. If you are pursuing an employment-based, that's what EB stands for, employment-based application, most employment-based applications in terms of the adjustment of status are actually being sent to the National Benefits Centre. From a positive standpoint, we're actually seeing the majority of those now actually be adjudicated and approved and processed without a final interview. So USCIS are now allowing the central offices, central processing centres, to actually adjudicate these cases and issue green cards without the individuals having to go to a final interview. So those are a couple of positives. However, we're seeing some sort of detrimental administrative processes as well. If you file for your work and travel permission based upon your adjustment of status, for a number of years now, they've been issuing what we call a combo card. The combo card looks like a little driver's license. It's a combination card that includes both your work and your travel. And we're now seeing the work and travel actually being separated out and a lack of combo cards being issued. That can lead to some collateral damage for applicants, because if the work and travel are issued together, then generally speaking, there's not a problem with being able to travel while an application is pending. But now that's bringing some cases and difficulties for individuals. So they have a tendency now to issue the employment card first and then issue the travel permission later. We are certainly seeing more significant visa retrogression this year than we have seen in quite a number of years. What that means is we're seeing a lot of usage of immigrant visas, and we're seeing, certainly for all countries now under EB2s are retrogressing. We're seeing retrogression even in EB1s, and certainly more significant visa retrogression for Indian and Chinese nationals. Just a quick note there, this happened last summer. Department of Education withdrew certification of ACICS as an accrediting institution. It could have a detrimental effect if you were at one of those institutions. It's just something to flag and check on. So what's new, or what's maybe recent, is a better way of putting it. Deference to STEM. So for a number of years now, immigration is obviously a very broad area. We have even professional immigration and business related and employment based immigration is quite broad in its own nature. There's been for quite a period of time now the idea or sort of calls for scientists, researchers to maybe get a little bit more weight added to their potential cases. And back in January of 2022, we got some traction. And so basically we got some additional deference to STEM, that the Biden administration published some guidance in January of 2022, providing additional deference and weight for STEM related applications. So what does that mean? It means that when you may file for a national interest waiver, an employment-based second preference, and or an O1 visa, that the evaluation of the supporting evidence, if this is a STEM application, is supposed to be given more deference and weight. So for example, now a PhD in STEM is seen as persuasive for a national interest waiver application, with additional weight being granted to expert letters from governmental entities and agencies. New fields of study have now been included for the STEM OPT. I want to be clear, however, that while there is additional traction and weight possibly being granted to the types of evidence and documentation that someone may be able to bring to the table, this doesn't mean that suddenly these types of applications are easier. I think it opens the door for them potentially being viewed as a slightly less restrictive by immigration officers and adjudicators, but they're by no means easy, I will say that. So what are the types of issues and questions that a foreign national researcher or scientist will be asking themselves while sort of residing and being employed here in the United States. So, you may have been here for your PhD, you may be in your postdoc, you may be slightly further along. So generally the questions are, well, do I want to stay in academia or do I want to transfer or try industry? What's the best visa for me? Is it a J1 or a H1B? Should I continue on my OPT? If I'm on a J1, can I transfer it? Can I transfer it within academia? Can I transfer it to industry? What about an O1? Is that in play? Is that something I should look into? Is it an appropriate next step? And ultimately, as a foreign national residing in the United States, the final question is, well, do I ultimately want to be here temporarily, or do I want to make this place make this country my place of permanent residence? So those are some of the issues and questions that you will be addressing yourself as you sort of navigate this journey. So I'm going to run through some of the most common visas, I suppose. I could probably do a whole seminar or webinar on the F1 OPT and the STEM extension, but suffice to say, this is the quick editorial summary. You get, after your PhD, you can get your OPT, post-completion OPT, and then you can file for your STEM extension. Once you file for your STEM extension, it is valid for an additional 24 months. You must have a qualifying STEM degree. The employer must be e-verified, and there must be a bona fide employer-employee relationship. If you are to utilize your OPT, your post-completion OPT, and or your STEM extension to leave academia and transition to industry, just be careful about the next steps, because it is possible that you are potentially reducing your visa options, and you may be more reliant then, for example, on the H1B cap, as opposed to if you stay in academia, things will have a tendency to be a little bit more seamless. So I'm just flagging that as a potential issue. We have the J1. I think from the number of people who provided input, the most common visa in today's audience is in fact the J1. And there's a lot to be happy about. When you have a J1, you generally don't have to deal with USCIS, and that's not necessarily a bad thing. Fairly easy to administer and is mostly transferable within academia. A little bit more problematic from an industry perspective, although that is changing for the better. If you're married, your J2 spouse can apply for J2 employment authorization. And there are some tax treaties which can, in certain instances, confer some benefit upon you. However, one thing to keep in mind and to sort of understand is the 212E. So the J visa is an exchange visitor program. And if you are subject to 212E, it means you have a 2-year home residence requirement. If you are subject to that, which will generally for researchers stem from being on the skills list of your home country, or that you got government money from the US government or your home country, you have to either fulfill that or get a waiver. If you're subject to 212E, you need to get a waiver for either the H1B or the green card, and you cannot change status if it applies. So it's important to look into and make sure you're knowledgeable about whether in fact you are subject, and if so, why. If there's a discrepancy and you're sort of on the fence, well, my visa says I'm subject, my DS 2019 says I'm not subject, you can actually go to the US State Department and get an advisory opinion, in which case they would essentially indicate to you, make a finding and say, okay, we are stating or finding that you're subject or not. So what about the H1B? The big one for the H1B is whether you are cap exempt or cap subject. Essentially what that means is that academia and or nonprofit research organizations are exempt from the cap. Therefore, an employer such as that can file a H1B for you at any time. That is not the case in industry. Industry, I use that term very broadly, for-profit industry. So the cap was reached for this fiscal year back in April. So if an industry position or if an industry company wanted to offer you H1B, the next time they would actually be able to file for you, unless you currently hold a cap subject H1B, would in fact be, April, May of next year. One of the differences between the H1B and the earlier visas I noted is that the H1B is dual intent and can actually be maintained up until the day you get your green card. However, important to note that you should know the policy where you are now, because certainly universities and research institutions, may look at titles and positions a little differently. University A may say, yes, you're in this title, you have this title or this position, we will file a H-1B for you. University B may say, well, no, even though we can do it, our policy is that we do not, and we request that you be in a certain higher level position, etc. So again, important to note, get the information from your employer, your company, your organization, your institution. So it's not what people can do, it's what sort of policy and procedure indicate that they generally do or will do. Under the previous administration, there was a lot of scrutiny and adjudication issues with H-1Bs related to wages, types of positions, etc. Certainly in the field of computer programming, a lot of data, software positions really came under a higher level of scrutiny under the previous administration. I think we're seeing less of this now, but it can still be an issue, especially with certain, I think, computer programming positions, if that's in play for anyone here. We also have the O1. I noticed that there was a number of people had been on the O1 today, so I popped this in here. So it's a much more restrictive standard than the H-1B, the J-1, etc. A couple of things to say about the O1. It's very similar to the EB-1A extraordinary ability standard. So you really have to have strong professional credentials, and you have to have substantial evidence and documentation. However, as I mentioned a moment ago, if you're on a J1 and you're subject to the 2-year home residence requirement, you are not required to obtain a waiver to get an O1 visa. So if you are a person who has an outstanding 212E requirement, i.e. you're subject to the 2-year home residence requirement, an employer can file an O1 on your behalf. Once that application is approved, you can leave the United States, get an O1 visa stamp and return. Now, you would still be subject to 212E, but you would have been able to sort of navigate it in the short term to get this visa stamp. It's also a good option for industry when there are no H-1Bs available, because there's no cap limit on O1s. There's also no discernible time limit on O1s. As I mentioned, it is a restrictive standard, but as I noted a few slides back, given the recent deference to STEM, it's sort of opening the door a little bit further for potentially more individuals to be able to qualify and be approved for the O1 standard. However, I still think, you got to look at these things on a case-by-case basis. And, unfortunately, not all adjudicators are maybe consistent. And so therefore, for some, do they really apply the deference to STEM? But I think broadly speaking, the STEM deference under the O1 visa does give more individuals an opportunity to be sponsored under this visa category. Note, you do require an employer to sponsor you for the O1. So those are the main. I did see, a couple of other people may have been on TNs. Those are for Mexican and Canadian nationals, professional visa, and again, need to be sponsored. They are not dual intent. However, that's just a quick note because I did see some people holding that visa status. So regardless of, what your current visa status is, how you're trying to navigate this, are there added pressures and or responsibilities that you're trying to navigate and deal with? So do you sometimes feel constrained with regards to your visa situation? How are you going to work this out? Well, if you do, think about the alternatives and think about the options that are in front of you. Regardless of whether you are in academia or in an industry environment, find out your employer policies. And I mean that potentially in terms of institutional or company sponsorship being a possibility. Have the conversations at the appropriate times. I don't necessarily think that getting a H-1B on day one and day two, knocking on people's doors, asking for green card sponsorship may be the most or the best way to navigate this. But I think having the conversations with the appropriate people at the appropriate times, is the way to go. You don't want to leave yourself in a position that you find sort of 4 years and 9 months into your H-1B that there is no avenue to be sponsored at this company and or organization. You do want to have these conversations earlier to at least see what is in front of you. But I will say this, And as I mentioned earlier, business immigration, employment-based immigration, professional workers in the United States, there's millions and huge numbers. But for scientists and researchers, as highly qualified individuals who are working in areas of national importance, you have options that many other people do not. And I think it is important in the current climate to sort of know and understand what these options are. So, are you, for example, aware of self-sponsored green cards? The majority of professionals in the United States will require an employer or potentially a family member to sponsor them for a green card. But you may be able to self-petition. You may be able to self-petition and then apply that knowledge base outside of academia and apply it in an industry or other perspective. So how does it all work? Well, we have employer versus self-sponsored petitions. An employer-sponsored application is what I would term the traditional method and somewhat easily navigable for the employer. It's a series of steps, a series of events called PERM. The employer is the one driving the bus. Under a self-petitioned application, however, you as the individual are the one driving the process. And therefore, it clearly can give you additional options and can open additional doors for you from a career standpoint. But it is a restrictive standard. So I think it's important to be prepared to understand the process before sort of diving headfirst into it. So what about the idea of either transitional or non-traditional fields? Are they allowable within a self-petitioned application? Because a self-petitioned application infers that you will continue to work in the same or similar field under which you are engaged at the time of filing. And I'll go into that a little bit more in a few minutes. But ultimately, if you can process a self-petitioned application, I think it's clear that you will have more options regarding ongoing and longer-term employment than the employer-sponsored process. Here's the options for employer-sponsored green cards. Well, first we have PERM, which I would term the traditional method. Employer advertises the position, then you file with Department of Labor. And if the case is certified, then you can file with USCIS. In a university setting, we have what's called PERM special handling, which allows for universities to recruit the most qualified applicants. So it's similar, but a little different to the traditional method of PERM. And then we have the outstanding researcher. Again, no advertising here. It's sort of more similar to the EB1A extraordinary ability and national interest waiver. There's much more based upon the substantive nature of your professional contributions and accomplishments. Again, however, this is an employer-sponsored application. They have to have at least 3 full-time research employees, and the position needs to be permanent. So all of these are where an employer sponsors you for a green card. However, what about the idea of self-petition green cards? So is this something that you as an individual can consider? And here's the first questions that you need to ask yourself again before you sort of take these steps to say, yes, this is something I'm going to do. So first of all, what is it? Well, it's a self-sponsored application. You as the individual are sponsoring yourself, so you don't need an employer to be part of it. So what are you asking? Well, in many ways, it's a sort of fancy way of asking a very simple question. Do I qualify for a green card? Do I qualify for a green card as an alien of extraordinary ability? Or do I qualify for a green card as an advanced degree alien performing work in the US national interest? Well, the next sort of logical question to ask or step to take is, well, am I qualified? You need strong professional credentials. The importance of your work is not in and of itself enough. And we're going to go through some of the sort of most relevant factors to look at that. So what can you do? I think it's important to prepare yourself, be ready if this is something you're going to pursue to sort of go to the well at the correct time. I think it's always important to get a full and frank evaluation of your credentials. So for example, here at Frank and Delaney, many times we will be happy to look at people's resumes, their CVs, and give some feedback in an initial consultation to indicate where we feel the strength of a potential application would be. Are you ready to potentially file sort of now or in the near future, or do you need to continue to enhance your credentials and get yourself to a point where the application will be stronger? So I think a full and frank evaluation of your credentials is important. So there's 2 ways that you can self-petition. The first is extraordinary ability. If you have a one-time achievement, a major internationally recognized award, if anyone has a Nobel Prize sitting on their mantelpiece at home, you will get approved. If you do not, you still can get approved by meeting 3 out of 10 listed criteria. Now, certain criteria are objective versus subjective, and that's important to note and understand. And it's also important to understand that not all of the following criteria actually pertain to the sciences. So if we look at the 10 categories that are, under the EB1A extraordinary ability, we see some of them, for example, over on my screen, the right-hand side, evidence of your commercial success in the performing arts. That's got nothing to do with the sciences and therefore would not be an appropriate category to go after. And similarly, in the middle, evidence that your work has been displayed at artistic exhibitions or showcases. It doesn't apply because extraordinary ability can relate to any professions. So which categories are you most likely to be able to go after? Well, we would look and say evidence of the authorship of scholarly articles in professional or major trade publications or other major media. So if you've published, if you've disseminated evidence of your research accomplishments, you'll be able to meet that category. If you've peer reviewed, you would be able to show that you've judged the work of others. After that, some of the others start to become a little bit more subjective. So we say, can you show that you maybe have performed a leading or critical role in an organization of distinguished reputation? Possibly. The big one that you really almost need to get is evidence of your original scientific contributions of major significance to the field. And in that sense, you have to sort of break that down. The accomplishments or the contributions are certainly original in nature, and depending upon the manner in which they may have been published, presented, disseminated, or recognized by others, you may have a pretty solid argument that they were significant. So in many ways, it will come down to that little word major. Can this contribution be seen to be a contribution of major significance? And so that is obviously a little bit more sort of discretionary and subjective. And it's therefore important to have sort of substantial evidence and documentation to back that up. Once you meet 3 categories, you then, by a sort of totality of the evidence, have to show that you're recognized as one of the few at the top of your field. You have to show that you've garnered sustained national or international acclaim, what I would term a consistent career of excellence. I think generally speaking, it's fair to say that it is very rare that if a scientist or a researcher can harness sort of 3 categories that immigration would find that part 2 analysis is not met. But EB1A is a very restrictive standard. For most postdocs and researchers, the EB2 national interest waiver will have a tendency to be a better alternative. Here we look at the sort of cumulative and broad analysis of your overall body of work. However, I will say this again, that the sort of mere act of publication or presentation, the dissemination of your work in and of itself is not going to be enough. There's got to be detail, there's got to be substance behind it. However, as in the EB1A, you as the applicant, the individual, you're driving the process and you're not tied to any specific employer. The test under the EB2 is different. First of all, you have to show that your work carries substantial merit and national importance. And traditionally, anyone involved in scientific research will be in an excellent position to show that. Secondly, we have the meat of the application, that the foreign national is well positioned to advance the proposed endeavor. And this is where you bring you bring your A game. You bring what you have accomplished. You bring the publications, the citation history. You bring all your evidence to show that you, as the applicant, the individual, have an overall body of work that you can be seen to are well positioned to advance this field. And then ultimately it would be beneficial to the US to waive the requirements of a job offer and labor certification. So unlike the EB1A extraordinary ability, you don't have to show that you're one of the few at the top of your field. You don't have to show this idea of sustained national or international acclaim. You essentially have to meet this test. So again, it's not an easy standard to meet, but it's certainly less restrictive than the EB1A. So what are we looking at here? Well, we look at citation, and for researchers, I think citation continues to carry a high degree of importance under the EB1A standard, perhaps less so in the EB2. But what are we looking at? It's not just the fact that you may have published, presented, or disseminated, but what about the cover articles? What about the editorial highlights? What about the standards of your publication and the journal rankings? This all comes into play. the burden is on us to sort of organize, structure, and present the case in the strongest possible manner. Can we show that others may have utilized or implemented your findings in their own? Again, that would tend to show recognition. That would tend to show advancement in the field. Can you show documented role in grants and funding of your work by organizations, institutions, etc.? And ultimately, the question is, can you show that you're one of the few at the top of your field, EB1A, or how well positioned are you to advance the proposed endeavor, EB2 NIW? So how strong is my case? And I think it's fair to say that while there will be overlap for many different sort of cases that we look at, there's not necessarily, again, a one-size-fits-all sort of strength of application. When I look at different resumes, I can see different strengths and what different people bring to the table. For one, there may be an extensive history of publication and citation, and that may be the strength of their application. For someone else, they may have been conferred and awarded significant grants by research institutions, etc. Other facets and that you can sort of show is your work as a peer reviewer. I don't necessarily mean or feel that you peer review once or twice and suddenly your case is remarkably strong. But if you've been invited to peer review on a number of occasions, perhaps served on an editorial board or boards, etc., that can certainly show that you're well regarded by others in the field. And then we have the expert opinion letters, the recommendation letters. Again, what this does is I don't think those should necessarily form the sort of basis of your application, because an immigration officer may look and say, well, that's nice that they have sort of 7 or 8 crackerjack letters. Those may have come from colleagues or friends in the business or in the industry. But I think if you can get strong high-level letters from well-regarded individuals that can corroborate and confirm the evidence in the record, then yes, they do bring weight to the table. But I think at the end of the day, you need to have a well-rounded application, and you really need to have that sort of substance. One thing I say when I engage in initial conversations with people and I look at their resumes is, all of the research is important, but not all of the research is significant. And I think the burden is on us to compile, organize, structure, and present an application that communicates the significance of the research in an application that we are filing. Network, use your professional relationships to make sure that you can obtain the strongest recommendation letters or professional, support that you can as you sort of get into this process and get to the point of being able to file one of these applications. So we look at the idea of transitional, non-traditional careers, industry-based processes. I think a number of years ago, the idea of pursuing a self-sponsored application sort of almost tied you to academia. But it's clear now that in pursuing a self-petitioned application, a self-sponsored case, while you're required to work in the same or allied field of endeavor, the application of your scientific knowledge can enable you and allow you to apply that in a number of different areas, whether it is in sort of traditional academic research, industry-based research, entrepreneurial avenues. So there are now a number of ways that you can show that you're continuing to work in what we would term the same or allied field of endeavor, because the application of your scientific knowledge can be used, utilized, harnessed in a number of different ways. So going to finish up now in the next couple of slides. We're just going to do some housekeeping. Now that we've sort of walked you through the process, we've sort of, you maybe have filed and get approved for an EB1 or an EB2. You're like, okay, cool, let me get my final green card. Well, perhaps not so fast, unfortunately. So the United States gives out 140,000 green cards every year. Seems like a lot, but this is a pretty big country. There's a lot of people sort of looking at obtaining a green card based upon prior approvals. Essentially what that means is the employment-based final green cards are broken down by category. EB1, first preference. Employment-based first preference includes extraordinary ability, includes standing professor or researcher. They break these down into sort of 3 different columns. We have all countries. Here it's everyone. And we have India and China, because India and China over the past about 15 years have more heavily oversubscribed their numbers. So what this means is in the current visa bulletin, which is July of 2023, we're working off of final action dates. Everyone is current, means you can file your adjustment of status with your I-140. However, India is back on February 1st of 2022, as is China. Next month, on August 1st, we are seeing significant retrogression, but essentially they're running out or have run out of visas for the end of this fiscal year. So we would expect to see forward movement in October, okay? Now, the problems are even worse under the EB2. Now, all countries are currently backdated to February 15th of 2022. That means that you would have had to have filed your EB2 national interest waiver or PERM on or before February 15th of 2022 in order to be able to file your adjustment of status. For China, that date is June 8th, 2019, and for India, it's a remarkable January 1st of 2011. What that means, most notably for Indian nationals, to a slightly lesser extent Chinese nationals, and actually for everyone over the next number of months, is you are going to have to continue to maintain a valid non-immigrant status in order to remain here in a valid status. So that's how that's all playing out. I would suggest for everyone to keep an eye on the visa bulletin over the next couple of months as we finish this fiscal year. Notably, the visa bulletin that's going to come out in September, which will show us what's happening in October, I think is going to be an important one because we're going to hopefully see what the forward movement looks like. However, for China and India, you can hold your place in line if you file an EB2. Sometimes people from China and India are like, well, what's the point in an EB2? Well, there's a couple of benefits. First of all, it can allow your H4 spouse to apply for work authorization. It can enable you to extend your H1B beyond the 6-year limit, and it can also hold a place in line for a subsequently filed EB1. So some of these are difficult and it can be frustrating. But I think if you are sort of mature enough to sometimes take a step back, look at pragmatically, and learn how this works and what is in front of you, you can take the steps to get where you want to be. And I know it can be frustrating, but at the end of the day, science is recognized for its importance here in the United States. And I know sometimes it may not feel like this, but so are international researchers. So as I mentioned earlier, you guys do have sort of the opportunities, potential pathways that many other highly qualified professionals do not. So ultimately, with the proper guidance, you can get to where you want and need to be, okay? So take that in stock and be positive as you can navigate this. And just some final housekeeping in terms of current immigration situations. If you need a new visa stamp, set up any appointments well in advance. Please don't drink and drive. I'm not here to do a public service PSA, but if you do, you can get your visa revoked. You do not even need a conviction. We are in an era of extreme vetting at airports and ports of entry. They are potentially asking for phones and computers. On a more positive standpoint, immigration have indicated they will return to giving deference to prior approvals, which is good. If you file an extension of your H1B, an extension of your O1, they're supposed to just look at the previous approval and extend the new one. And yes, I live in Washington, DC, and sometimes they even do stuff down at the Capitol, not a lot of immigration stuff though. It's been a rough year. It's been a rough year for case processing, and it's been frustrating. People ask me all the time, will Congress pass a bill? At one point, we thought reconciliation was maybe going to be the answer, but it's not looking likely. But I do want to finish on a positive note that, as I mentioned earlier in this talk, STEM is now in play. That is published guidance from the administration. That is a big step forward for you guys. So let's see how the guidance will be applied and the extent to which it can be seen as positive traction for the applications that we talked about today. So with that, I'm going to finish up and say thank you. I mentioned earlier, LinkedIn. I'd be happy to, if anyone wants to connect with me on LinkedIn, and I will go ahead and stop sharing my screen now, right? And we'll go to Q&A. All right, sounds good. All right.
We'll go ahead and jump in to get as many as possible. So one question I had that you went over a little bit was the differences between the EB1 and the EB2, but one difference in particular is there a difference in the length of time to actually obtain the work permit associated?
So the work permit is actually associated with the adjustment of status. So the immigrant petition, which is EB1A, extraordinary ability, or EB2, national interest waiver, as I said, that's a fancy way of saying, do I qualify for a green card? Now, when people can then file to get their work permit, can depend upon country of origin and can depend upon the visa bulletin. For the most part, people from all countries for the last few years really haven't had that extensive of a wait time to get their employment authorization based upon EB2. However, we are seeing more retrogression this year. So once you file the adjustment of status, then there shouldn't be a time difference in how long the EAD takes to be issued. So it really comes down to when you can file that adjustment of status.
Great. We have a couple of questions related to like sort of family members. So for example, what is the oldest age a dependent can be if you want to bring them over with you on either a J1 or an H1B?
For those visas, it's 21. There are limited exceptions. There's limited exceptions. I think it's G4 for international organizations, where I believe the derivative can be a little older. But generally speaking, once the child turns 21, they are no longer a child for immigration purposes and would need their own visa.
Right. And if you are a dependent of someone who's an H1B holder, can you work in the US or?
Under very limited circumstances, and so I just mentioned it quickly, is that generally speaking, H4 non-immigrants are not eligible for work authorization. However, if the principal applicant, if the H1 has an approved I-140 and there is no visa availability for them to file their adjustment and get their work permit based upon that, then the H4 can file a work permit to request work authorization themselves.
Right.
So all of those dominoes have to
fall into place. So it to apply. So O1 is more for industry, but if you're in academia, are there any positions that would make you eligible for an O1 within academia?
So that's really a sort of case by case, an employer by or an institution to institution basis. So one thing to just remember about the O1 is that while it requires extraordinary ability of the applicant to be approved, it's not a requirement that the position requires someone with extraordinary ability. So really it's at the discretion of the sponsoring employer whether they see a position as being appropriate for O1 sponsorship. And just as a maybe a quick aside or an example of that, if, for example, the person in academia has a 2-year home residence requirement and they may be, somewhere on the organizational ladder, they could still do an O1 for them, even though they're not in the upper levels. But again, it's going to be their decision to make. So they can, whether they do or not is a different question, I suppose.
Gotcha. And then this question is around whether or not it's possible to extend the number of unemployment days allowed under the F1 STEM extension. So for example, the pandemic.
That would be that's quite a specific regulatory based question. So I wouldn't want to.
Got it.
That's pretty detailed.
Okay, sure. We'll get to some that are more general, and these are primarily around timing, right? So what is the right time that you should apply? For example, if your university is offering you the option to switch from a J1 to an H1B, should you try to wait and get all of your 5 years of J1 in before switching to an H1B, or should you just switch when they offer?
I think that's a judgment call on a case-by-case basis. So let me maybe give a couple of examples as how it may play out. So, the H1B is going to be good for up to 6 years after that J1 ends. Mm-hmm. So if you're relatively confident that the platform or the foundation of your research work at the time of making the transition to H1B is solid enough that you will continue to accomplish and move the field forward, then you're probably going to be fine. Now, let's say, for example, the first 3 years of your J1 research position, unfortunately, just nothing really got accomplished. And you had sort of been hoping to maybe have additional publications, but it just didn't come to fruition for whatever reason. maybe then you might say, well, it might be better to stay in J1 a little bit more. I think it's the sort of thing that you also may want to be contemplating employer-employee relationships. So I think there's a number of different factors that would go into making that decision. One thing to just maybe put a finality on that is that when an employer, if they're sort of saying, look, we want to transition you over, then it just may be, okay, at the end of the day, as I said, in an employer-sponsored application, they're the one driving the bus. So it might just be time to make that transition.
Got it. So a lot of people also want to know, is there a magic number of citations or a number of grant money awarded or anything like that that is kind of a guarantee to get that self-sponsored or NIW?
So good question. And I see it a lot. And I'm going to say no. And the reason why I say that is that I think it's fair to say that as we look across different scientific and research disciplines and arenas, then the driver can be a little different. And I suppose what I mean by that is we've had the good fortune to work with a number of aerospace engineers out at sort of NASA Goddard. And a lot of those folks actually have a very limited number of citations because from an engineering perspective, the strength of their application probably, tends to come from a different perspective. And yet their lesser number of citations may actually in some ways mean more because they may be sort of overachieving in terms of they may be published in a journal that is it has a lower impact factor, but their citation numbers may be higher. So I think that goes back to what I said during the webinar, is that it is important to get a full and frank evaluation of your credentials. Because when I do look at people's CVs, we will look and be like, oh, your citation numbers are in the hundreds. Oh, you have an excellent platform and foundation for an NIW. Your citation number is much lower. Okay, we got to address that. And while that's not going to, kill your application, what else do you have? Because with a very small number of citations, the door is ajar for an immigration officer to focus more on that. So that's why I think it's important to look at the bigger picture. But, and so usually when I sort of look at someone's CV, I have that discussion to look at each thing on a case-by-case basis.
Got it. So another set of questions relates to location. So can you be in another country when you apply for the J1 waiver, or do you have to be in the US at the time of that application?
For the J1 waiver. Okay, so for the J1 waiver, the issue with my answer to this is technically you can be anywhere because the State Department is the ultimate authority. Well, they're going to recommend it and then immigration approves it. But once State Department recommends it, immigration approves it. And they don't really care where you are geographically for you to make the application. However, you also have to keep in mind that one of the interested parties in a J1 waiver application, assuming we're talking about a no objection here, is your home government. And so therefore, I obviously can't speak to what all the policies and procedures of the different home governments are. And so it's going to be important for you to make sure that you are adhering to their policies. It is conceivable that a government somewhere may say, hold on a second, we will only provide you support for a waiver if you're physically present in the United States. I don't know that to be the case, but you just got to make sure that for your home government that you're adhering to their policies and procedures.
What about if you're on OPT? Do you have to be in the US looking for work, or could you be looking for work abroad, but still?
This goes into the OPT regulations. There are significant regulations authored and written about the OPT, about what you can and can't do. So when I get into those types of questions, I really prefer to defer. We would have to look at these specific regulations. There are periods of unemployment allowed, things like that. But one thing I will say actually in response to that question is, because of the pretty intricate regulations that have been published over the years with regards to OPT, you really got to be careful that you're continuing to engage in any activities that are authorized, that you don't want to be doing something that's unauthorized, because that can have a detrimental effect on your status.
Right. Okay. And we have some more questions around timing. So when should you apply for a green card as a J1 visa holder if you're not subjected to 212E, and then also if you are. So both sides of the question.
Sure. And these are the types of questions that are really a case-by-case basis. And again, I try to give a couple of examples as to why. So there are a number of universities and institutions, for example, that issue J1s on a yearly basis. And so while you may have a total of 5 years available to you, they're sort of issuing it 1 year at a time. And if that's the case, then you're sort of saying to yourself, okay, what's that magic time to sort of, you probably want to get another year issued before you do it. Now, maybe I'm not subject, so maybe then at some point I'm transitioning to H1B or filing for a green card. If you're subject to 212E, you've got another sort of scenario or issue or problem, is that there's really nothing to say, okay, I file it. Like, okay, that's great. But attached to that, even if you get your green card application filed, your immigrant visa, immigrant petition for alien worker filed and approved, you still have the 212E hanging over you. You got to be sort of moving forward in parallel with that to make sure that suddenly at the end of it, you're not negatively impacted by not addressing the 212E. So generally speaking, those would be the sort of the issues and scenarios that we want to look at. When someone has a 212E issue, a 2-year home residence requirement issue, I'm always going to sort of flag that and say, okay, we could go forward with the green card whenever, but we got to deal with this on the side. And you want to make sure that they don't suddenly come into conflict down the road.
Got it. So this is a question about what visas are easiest to travel under. So if you just want to take a quick vacation to a third country or whatever, like which of those visas is kind of the best for someone who wants to be a bit more mobile during their time?
Well, if you're talking about the idea of traveling while pursuing a green card application, then there's no question that it's the H1B. The reason I say that is that the H1B is what we call, and I mentioned this in there, it's called a dual intent visa. So USCIS, CBP sees no conflict, no problem, no issue, ongoing travel in and out on a H1B while a green card is pending, has been filed. You can continue to use that H1B up until the day you get your green card. So there's no question there. The F1 and the J1, once you file a green card application, you shouldn't be traveling on those. Caveat, no idea of the country of origin of the person who posed the question.
Right.
And just one thing to flag is that generally speaking, the visa stamp is issued based upon what we call reciprocity. And so, for example, most visas are issued with a little M in there, which means multiple entry. But it is possible that you're from a country that they only issue US citizens, maybe a single entry visa or a dual entry. So you might only have your visa issued for that. And if that is the case, then unfortunately, multiple little trips in and out can be more problematic.
Got it. All right, we're going to do one last question to wrap things up. And it is about whether or not you're allowed to work remotely for an employer outside of the US, but while you are in the US after you have received, say, EAD or OPT. So you're here in the US, you have OPT. Can you work part-time remotely for another employer outside the US?
If you have an EAD, you should be fine. So I'm going to, again, sometimes I have to infer some things and just I want to also be cautious and careful that circumstances may dictate this. And so I can't give an absolute answer, but let's say, for example, someone has got their EAD based upon a self-petitioned green card, and therefore they are continuing to work primarily in their field of expertise, in their field of endeavor here in the US for a US employer. Well, then yes, side positions or other positions would be okay because the main endeavor continues to be related to the green card application that was filed. If that is not the scenario at play, I think you would want to be cautious and careful to make sure that you're not doing anything that would be outside of what is indeed permitted.
Great. Well, thank you so much, Brendan. And I just want to, again, thank you so much for your time. I'm sorry that we did not get to everyone's questions. I have put a link to Brendan's LinkedIn in the chat, so you can reach out to him with further questions. I've also put my email, so feel free to reach out if you want non-immigration related help with your career development. And I've also pasted the links to the current jobs we have with companies that are willing to sponsor visas. And feel free to make a profile at scismic.com, which will help you match to jobs that fit your visa status. So thanks, everyone. Thank you so much for coming. And thank you, Brendan, for your time. We really appreciate it. Thank you, everyone.
Awesome. Thanks so much. Take care.
Thanks. Yep. Bye.